Todd Briscoe of Briscoe and Associates presents the California Tenant Protection Act of 2019, also known as AB 1482.
Good afternoon. This is Todd Briscoe. We're talking about the Tenant Protection Act of 2019 for California, AB 1482. I'll jump right into the material. And California AB 1482 mandates statewide rent control and just cause eviction. We're going to talk specifically about the just cause termination and the rent control components as we break those down. So the just cause termination, we'll explain that first. And the properties that are exempt, okay, all the units exempt to this just cause component are one, existing properties subject to local rent control ordinance requiring just cause for termination, okay, or any other rent control adopted after September 1st, 2018 by a particular city. Transient and tourist hotel occupancy, as defined by Civil Code 1940, Subdivision B. We also have nonprofit hospitals, religious facilities, extended care facilities, licensed residential care facility for the elderly, adult residential facility. Number 4 are going to be dormitories owned and operated by an institution of higher education or in kindergarten and grades 1 through 12 inclusive. 5, housing accommodations which the tenant shares a bathroom or kitchen facilities with the owner who maintains the principal residence at the residential real property. Number 6, single-family owner-occupied residences, including a residence in which the owner-occupant rents or leases no more than 2 units or bedrooms, including but not limited to accessory dwelling unit or a junior accessory dwelling unit. 7, a duplex in which the owner occupied one of the units as the owner's principal place of residence at the beginning of the tenancy, so long as the owner continues residency. And then we have housing issued a certificate of occupancy within the previous 15 years. That's a rolling 15 years and will continue to shift throughout the state law. So therefore, properties built after January 1st, 2005 are not subject to this new law. And that's going to be a majority of the members, at least through NAA. Number 9 is residential real property that is alienable separate from the title to any other dwelling unit, basically meaning single-family homes and condos. And then provided that the owners of the property is not a REIT, okay, as defined by the IRS, a corporation, or an LLC in which one member is a corporation, and then it obviously has to have special language contained in the lease notifying the tenant that they are excluded from this AB 1482 just cause exemption. And then we have housing restricted by deed, regulatory restriction contained in agreement with a government agency or other recorded documents as affordable housing for persons and families of very low, or moderate income, and that's going to be defined by Health and Safety Code section, or is subject to an agreement that provides housing subsidies for affordable housing for persons and families of very low, or moderate income, or comparable federal statutes. Okay? So if the property is subject to AB 1482, the lease or notice to the residents must contain the following language in no less than 12-point type. Okay, you have to have that. And then how do you deliver this language to the resident or serve the tenant? For any tenancy commenced or renewed on or after July 1st, 2020, as one, an addendum to the lease or rental agreement, or as a written notice signed by the tenant, that's key, with a copy provided to the tenant, or for any tenancy existing prior to July 1st, 2020, by written notice to the tenant no later than August 1st, 2020, or as an addendum for the lease or rental agreement. If the property is exempt, we recommend an addendum stating the exemption, not required. This could eliminate confusion among on-site personnel and residents or tenants when their termination notice is served. So also what I'm thinking is in the event that the case has to go before a judge, we at least list out what type of exemption list so all the parties are on the same page. And the provision must comply with Civil Code 1632. That's the language where you enter into or negotiate the terms of material terms of a lease in a different language, such as Spanish, Tagalog, Chinese. You then also have to provide this notice to the resident in that particular language. Okay. Now, if your property is subject to AB 14A2, then you have another layer you have to look at. Now, there's a 12-month exemption, just cause. If the property does not have a property exemption, just cause termination does not attach to the tenant until A tenant has continuously and lawfully occupied a residential real property for 12 months, okay? If any additional adult tenants are added to the lease before an existing tenant has continuously and lawfully occupied the residential real property for 24 months, then the subdivision shall only apply if either of the following are satisfied. 1, all the tenants have continuously and lawfully occupied the residential real property for 12 months or more, or 1 or more tenants have continuously and lawfully occupied the residential real property for 24 months or more. The key is going to be the 12 months. If your residents have been there less than 12 months, you can still provide your appropriate 30-day notice to terminate the tenancy. However, if you're on a 12-month lease, you can't not terminate it early. Can't give a 30-day during the midstream of the tenancy term. However, if you're on a month-to-month tenancy and something happens with the resident, the tenant, you can then at that point give a 30-day notice. And then if you have tenants coming and going, such as student housing, such as private student housing, that is 14A2 applicable, then you'll probably go into this further analysis of the 24 months. Okay. Prior to AB 14A2, an owner or landlord could serve a 30 or 60-day notice to terminate tenancy without any reason. Under this new law, a landlord will need just cause to terminate the lease of a tenant that has lawfully occupied a residential property for at least 12 months. Under the new law, just cause is divided into 2 categories. At fault, just cause, where the tenant has acted or failed to act in a way causing the termination, and no fault, just cause, where the owner of the property, government, court, or local agency has made a determination ending the tenancy, as opposed to at fault, just cause. No fault, just cause termination may require the landlord to provide relocation assistance in the form of 1 month of rent. Okay. And then at fault, just cause termination includes no relocation assistance. You can still remove a tenant for failure to pay rent, breach of a material term of the lease, including failure to correct any violation of the lease after written notice is provided to the tenant, just as you would in any 3-day notice to cure covenant, maintaining, committing, or permitting the maintenance of a commission of a nuisance or waste pursuant to the code. Tenant's lease terminates after January 1st, 2020, and after written request or demand from the owner, the tenant has refused to execute a written extension or renewal of the lease of an additional term, similar duration, with similar provisions, providing that those terms do not violate any law. Okay. Criminal activity you can still terminate for. Assigning or subletting the property in violation of the tenant's lease. Okay. Still unauthorized documents, that still applies. Tenant's refusal to allow owner entry into a property. So that's your 1954 notice to enter dwelling. If the resident fails to allow access, then you can serve a 3-day notice to cure covenant moving forward if they do not comply. Using the property for an unlawful purpose, an employee, agent, or licensee is failing to vacate the property after termination as an employee, agent, or licensee, or the tenant's failure to deliver possession of the property after providing notice or signing a written agreement with the landlord to vacate upon a certain date. Simple enough. If the tenant gives you a notice that they're going to vacate and they refuse to do so, you can enforce that. At fault, 3-day notice to cure covenant or quit. For curable violations of a lease, this is a change, an owner or landlord must notify the tenant of the violation with opportunity to cure the violation. If the tenant fails to cure the violation, the owner or landlord can then serve a 3-day to quit without an opportunity to cure to terminate the tenancy, and that's the change. In the past, we've been able to serve a 3-day notice to cure. If they didn't comply, we could go straight to eviction. In a lot of cases, in this case, at least legislature codified that, instructing us what to do. And no fault, just cause termination includes. And number 4 is going to be a majority of us, but we'll go work them through. Number 1, if the owner intends to occupy the property or by themselves, by the owner, or their spouse, domestic partner, children, grandchildren, parents, or grandparents, and they must have the termination language in the lease. Then 2, they withdraw of the property from the rental market. The owner complying with either an order issued by a government agency or court relating to habitability that requires vacating the property, an order issued by a government agency or court to vacate the property, or a local ordinance that necessitates vacating the property. Or the 4th is intent to demolish the property or substantially remodel the property in such a way that the work cannot be completed safely without vacating the property. Substantially remodel, and this is the definition by the legislature, means the replacement or substantial modification of any structure, electrical, plumbing, or mechanical system that requires a permit from a governmental agency, or the abatement of hazardous materials, including lead-based paint, mold, reasonably accomplished, mold, asbestos, in accordance with applicable. Okay, that's right. Let me back up on that. Substantial remodel means the replacement or substantial modification of any structural, electrical, plumbing, or mechanical system that requires a permit from a governmental agency, or the abatement of hazardous materials, including lead-based paint, mold, asbestos, in accordance with applicable federal, state, or local laws. That cannot be reasonably accomplished in a safe manner with the tenant in place, and that requires the tenant to vacate the residential property for at least 30 days. Specifically, cosmetic improvements alone, including painting, decorating, and minor repairs or other work that cannot be performed safely without having the residential property vacated, do not qualify as substantial rehabilitation. So the key is going to be the getting or obtaining a permit, as I see it. That will be a clear-cut sign that you can terminate the tenancy for a substantial remodel. Are there different methods, or is it possible to do without the permit? Perhaps. I would ask that you contact your local council to confirm, so you actually go through it. No-fault termination notice triggers relocation assistance or waiver of rent. Okay, for a no-fault just cause termination, the tenant is entitled at owner's option to either relocation assistance equal to 1 month's rent or the waiver of rent for the final month of the tenancy, with the exception that if a government agency or court determines that the tenant is at fault for the condition ordering the need to vacate, then the tenant is not entitled to relocation assistance. If an owner issues a notice to terminate tenancy for no fault just cause, the owner shall notify the tenant of the tenant's right to relocation assistance or rent waiver. If the owner elects to waive the rent for the final month of the tenancy, the notice shall state the amount of rent waived and that no rent is due for the final month of the tenancy. And any relocation assistance is provided directly to the tenant within 15 days of service of the notice. Should the tenant fail to vacate at the end of the notice to terminate, any rental assistance or waiver of rent is recoverable as damages in the eviction proceedings. Bear in mind, the legislature put strict compliance by owners, otherwise notice of void. So if you do not list as to which owner's option as to either going to waive the 1 month rent or pay the money within the 15 days, or if you don't pay the money within the 15 days, that notice determination of tenancy is going to be void and unenforceable. That will conclude the just cause portion. Now we have the rent control portion. And a residential property is not subject to both a local ordinance and this new law. Prior enactment to September 1st, 2019, local rent control ordinances shall apply and are not affected by this new law. If a city passes or amends a local ordinance requiring just cause for termination of a residential tenancy, the local ordinance is applicable if the ordinance is more protective. Okay, properties that are exempt. Bear in mind, this is a different list. There is some overlap between the just cause versus the rent control portion, and here's the properties that are exempt in the rent control portion. 1, housing restricted by deed, regulatory restriction contained in agreement with a government agency or other recorded document as affordable housing for persons and families of very low, low, or moderate income, or subject to an agreement that provides housing subsidies for affordable housing for persons and families of very low, low, or moderate income, or comparable federal statutes, same as the just cause. 2, dormitories constructed and maintained in connection with any higher education institution within the state for use and occupancy by students in attendance at the institution. This is a tick different than the just cause. 3, housing subject to rent or price control through a public entity's valid exercise of its police power consistent that restricts annual increases in the rental rate to an amount less than that provided by the statute. This is i.e. rent control. 4 is housing that has been issued a certificate of occupancy within the previous 15 years, exactly the same as the previous just cause. Number 5, residential single-family home or condo providing that both of the following apply. The owner is not any of the following: a REIT, a corporation, an LLC in which at least one member is a corporation. Or B, tenants have been provided written notice that the residential property is exempt from the section in the lease or an addendum. And then 6, a duplex in which the owner occupies one of the units as the owner's principal place of residence at the beginning of the tenancy, so long as the owner continues in occupancy. Okay. Question now is, if your property is subject to AB 1482, the rent portion, how much can the rent be raised and when? The initial rental rate. For any new tenancy, the owner establishes the initial rental rate. That will be market rent. Okay. This law is going to affect rent renewals. If the same tenant remains in occupancy of a unit over any 12-month period, the gross rental rate shall be increased no more than 2 increments over that 12-month period, subject to the following. A, increase not more than 5% plus percentage change in the cost of living, or 10%, whichever is lower, and of the lowest gross rental rate. In determining the lowest gross rental rate pursuant to the section, any rent discounts, incentives, concessions, or credits offered by the owner and accepted by the tenant shall be excluded. And then the gross per month rental rate in any owner offered discounts, incentives, concessions, or credits shall be separately listed and identified in the lease or rental agreement or any amendment to the existing lease or rental agreement. And then now you ask, hey, what's the percentage and cost of living? That means the percentage change from April 1 of the prior year to April 1 of the current year in the Regional Consumer Price Index for the region where the residential real property is located, as published by the U.S. Bureau of Labor Statistics. Okay, so example, that's going to be the CPI from April 2018 to April 2019 for all increases from this year going forward, actually 2020. Not all counties are published on April 1. More populated counties, such as Los Angeles, Orange County, Sacramento, are published on in San Francisco are published on April 1. Other counties are published on odd months, January, March, May, and etc. Okay. Some people always been asking, can ex post facto laws apply really to criminal and not necessarily civil, making this statute most likely valid. During the time period, and we have rent is retroactive in this case, rent increases occurring on or after March 15th, 2019 to January 1st, 2020. During the time period of March 15th, 2019 to January 1st, 2020, if a landlord has raised the rent by more than 5% plus the regional CPI, then beginning January 1st, 2020, the January 1st, 2020 rent is reduced to the maximum allowable rent. Tenant is not entitled to any resulting overpayment in rent. So remember, the statute was passed in September of 2019, signed by the governor in October of 2019, essentially rolling back the rents that you may have increased back from March 15, 2019 through January 1st, 2020. The alternative is during the same period the landlord increased the rent less than the permitted rate, then the landlord is allowed to increase the rental rate twice within 12 months of March 15, 2019, providing not exceeding 5% plus CPI, and that's collectively. Waiver of rights. Any waiver by a tenant of the rights and protections afforded on this new law will be void as contrary to public policy. So your lease or you cannot have a side agreement with the resident saying that we'll waive waiving AB 14A2. Just the court will not enforce it. Okay. There is a lawsuit that is challenging AB 14A2, and this was filed by Better Housing for Long Beach. And then there is a link for that. They're alleging that inverse condemnation. Okay. I have questions here, but I also have other questions that I will be able to go through. One is, question is, rolling 15 years since year of construction, does this apply on a monthly go-forward basis or an annual go-forward basis, monthly, yearly? You know, I think your conservative approach is going to be, it's going to be a daily. So if your certificate of occupancy was July 15th of 2005, then beginning July 15th, 2020, the property is going to be subject to this new law. And I think that's where you're going to be as opposed to monthly or yearly. You don't get, if the property was built in 2005, January 1st, you got your COO, I just don't think that you're going to be able to enforce a exemption on this property if your property had the COO on January 1st, 2005. I think on any time after January 1st, it's over 15 years old, which is then subject to this. Which CPI rate should we be utilizing for our calculation? Should we be using a bi-monthly CPI rate that comes out and adjusts every 2 months, or can we adjust one time per month? Every April, the CPI is adjusted compared to the last April. That's at least what this statute is telling us to do. As, for example, the regional CPI computed based upon April 2008 compared with the April 2019. If you have a regulatory agreement, government agency, you follow the regulatory agreement when exercising rent increases. For those counties that have the bi-monthly, for the odd months, recommendation, at least at this point, is look to the March 2018 to the March 2019 as your CPI increase. And I think that's the more conservative approach at this point in time. How would we be willing, the question is, how and when should we be rolling back rental increases to our current neighbors? Also, my understanding of the bill from Section 3 would mean that we could roll back the in-place lease rents, but we're not responsible to recredit current neighbors the amount that was overpaid. Correct. If a resident was increased more than the permissible rental rate, the rate is decreased effective January 1st, 2020 to the permissible rental rate. Remember, that's the 5% plus CPI, but no more than 10%. NA has a notice of rent adjustment or notice of rent decrease that you may provide to your tenants. The notice can be provided in December. Since it's a rent decrease, any time before January 1st is acceptable. Okay. Another question is the AB 1482. My question for Todd is the best practices approach for how to reconcile the state law with local rent control laws. For example, Mountain View allows banking of increases, 1482 does not, and increases in excess of 10% if a landlord petitioned for an increase granted, but AB 1485 is 5% plus CPI. How do we reconcile these? Also, what advice is the best practices regarding required AB 1482 notices? Since it's a rolling date, 15 years or older, it's an administrative nightmare for large portfolios, and we also, for properties that we have multiple buildings and varying certificate of occupancy dates. Best advice I can give is under AB 1482, there is specific exemptions for properties subject to rent control, meaning that no property can be subject to both AB 1482 and local rent control ordinance at the same time. I recommend placing a provision in the lease or addendum stating whether the property is or is not subject to AB 1482. If the property is exempt, then that property lists the exemption. As, for example, if the building has a certificate of occupancy within the last 15 years, list the certificate of occupancy date. This will lead to less confusion as the time marches. Then the on-site staff can understand whether or not the property is subject to AB 1482 or not. And then that goes for the tenant, too. I would like to know how rent cap increases work for leases and that are less than 1 year. The leases on our student properties are typically for 11 months and a week or two, not a full 12 months, and typically expressly state they do not renew. For students that want to stay renew, they execute a brand new lease. I would think the caps apply to the new lease, but they may not. Answer. Providing that your property is not exempt, and I take it that the property is not a secondary or higher institution for education and not owned by the college or university or higher education or JC, rent cap applies to all renewals. If your tenants vacate the apartment and then return to the apartment, you can charge market rent. However, if your tenants do not vacate and are renewed, you may only increase the amount to the permissible rental rate. So that's the 5% plus regional CPI, but less than the 10%. It does not matter that your lease states the lease does not expressly renew. Again, if your property is subject to the just cause termination, the landlord may only terminate for just cause, fault or no fault reasons. Okay. Also, the next question is RUBS, and I put the big gorilla in the room. Majority of the questions are surrounding this. Rent is not defined in AB 1482, which leads to problems for us as to operators to plan out what we can do or can't do. I believe what it's going to do is rent is going to be defined in our lease, and then that's going to tell us which way we have to march. If rent is defined to include utilities, pet rent, things of those nature, then it's probably going to apply. And being that the statute is vague on this area, the only way that's going to happen further is either further clarification by the legislature by amendments or through litigation and through additional lawsuits clarifying what is meant by 1482. So at this point, I think with RUBS is you're going to have to look to your lease and apply it there. I think it's going to be problematic for properties that do not have RUBS and then want to install RUBS. And I think that may be an issue because I think the intent of the legislature for the entire bill is 5% plus CPI increase. So if you raise your rent 5% plus the CPI and then you want to add into a RUBS component, I think that's going to look negatively by the courts. But then again, I don't have a crystal ball, and it's going to have to take it one at a time. So some questions also that I have received. If we have a current resident who has a renewal upcoming, assuming we offered them a 6-month renewal at 4% and then offered them the remainder of the CPI plus 5% increase in April at the time their lease is over, or would the increase for 12 months be held to 4%, meaning that we cannot offer an increase again until October 2020? Remember, you can increase the rent twice within a 12-month period, but no more cumulatively more than the cap. So if you raise it to 4%, you can charge the remainder of the 1% plus regional CPI increase on the second time around, as long as it's within that 12 months. You haven't raised it more than twice. So I think you're okay there. How should a property owner correctly calculate the inflation component of the allowed increases? Is there any way to otherwise increase tenant payments for an owner-paid utilities that are skyrocketing? Same question with respect to insurance. This law does not allow increases except for under the rent component. So you're not going to be able to increase more than the 5% plus regional CPI. And it does not take into account any additional costs such as insurance or utilities. Okay. And then please address the ramifications of the law for a small landlord with 1 to 10 units. For example, to me it hardly seems fair that newly constructed buildings in the last 15 years don't have to also abide by this ruling. Okay. There are exemptions for the 1 unit for single-family homes, providing that they're not in a REIT or corporation or LLC, or if an owner lives in a duplex, one unit is the whole unit is going to be exempt if 1 unit does. This law is specifically written to include roughly 8 million additional tenants in California. So, what about decontrol? When you have a tenant that has lived in our building for a long time and then moves out, you have to spend lots of dollars these days to fix the place up, and it's only fair to be able to bring it to present market rent. You can. Once a resident vacates the unit, you can bring the unit to market rent. There is vacancy decontrol, or there is no vacancy control, meaning that once the resident vacates, you can charge the market rent. Okay. How and when will the annual inflation numbers be determined? That's as I said earlier, by the Bureau of Labor Statistics, and you're going to compare it from April 2018 to April 2019. If you live in a county in which it's reported bi-monthly, then you're going to probably look to the March of 2018 to March of 2019. Okay. And then will the NAA add lease language that automatically raises the rent by the legal limit each year without notice or other action by the landlord? Not at this time. Perhaps that's one they can think about doing, but they're also not in the habit of managing the properties, so they try and get the lease, to the operators. Clearly explain the calculation of the CPI. I know that the April to April for all wage earners is defined for the region of year 1, but how will the CPI be chosen in the future? The change in the previous year and the month, the notice given, or the current CPI defined by the state? Let me ask another way. You raise your rent to a tenant on March 1st, 2020. Is rent 3.3%, which is the LA/Orange County CPI currently being used, or another date period? Okay. Yes, that's what the rate, you would add the 5 plus the 3.3% is what the maximum rate you can charge in California or in Los Angeles and Orange County that's where the property is situated. If a client owns a condo in an LLC, but that is their only residential rental, is it waived by the new law or does it make it apply? Depends. There is an exception if the LLC is not owned by, if the members are not a corporation. If it's individual, then that single-family home would be exempt. However, if a corporation owns the LLC or is a member of the LLC, then AB 1482 would apply. Clearly explain what amendments need to be added to existing leases and new leases for both units that fall under the new code are exempt. NAA has developed a lease addendum regarding this, and it has that particular language that you need in that addendum. So, due to the rollback to March 15, 2019, apply to cities that already have their own rent control. For example, Berkeley, no. So if the city has their own rent control, then this does not apply. AB 1482 does not apply. If someone returns their garage just before they renew their lease, do we adjust the 5% plus CPI increase down, or we don't exceed the maximum allowable since the rent has been reduced, the price of the garage? Can they claim improper notice since the amount in the renewal letter is based on all-in rent? In the garage was $75. So if they took back the garage at $75, I think your rent's going to be the 5% plus CPI, wherever the rent is, less the garage. Okay, I think that's how you get around that. So if you add an amenity or detract, there's nothing in this law that does not prevent you adding an amenity and adding a certain amount for that amenity, or the same thing if you take away an amenity such as a garage and you're charging $75, nothing in this law that precludes you from reducing that, taking that offline, and then figuring out your 5% plus CPI. I would like to know how AB 1482 affects cities that are already under rent control policies. I've already stated the rent control that still applies. If your city has the rent control, then AB 1482 will not apply to this. Some of the questions is can a family of 4 owner move into 2 units? Some cities limit the owner move into 1 unit. Yes, as long as you follow the rules in particular to that property, you can have an owner move in or a connected family member. You can move in, and you have to follow the notice of termination and pay the relocation assistance or the 1 month. How does the law directly apply to my LLC if it has only a few single-family homes in it? If, again, go back to the LLC, is it owned by a corporation, then AB 1482 applies. If it is owned by an individual, the LLC, then it is exempt. Okay. Is the act waivable? Express language prohibiting waiver? Yes, there is express language prohibiting any waiver of AB 1482, so the act is not waivable. Are there any specific guidelines for the rent rollback that has to be done for rents that were raised more than 7.2% after March 2019, or is it as simple as noticing the tenants like we would a rent increase, but letting them know that the reduction to hit the 7.2 allowed? In this case, for San Diego County, that's why we get the 7.2% versus the 8.3 for Orange and LA counties. Yes, it's that simple. It's that simple by giving your tenants a notice stating that the rent effective January 1st, 2020 is the rent plus the 7.2%. Okay. When does CPI come out for California? Like I said earlier, the majority of more populated counties, it's done monthly, and then the lesser populated counties are bi-monthly. What increase can be given to a vacant unit? And that's going to be market rent. Is there any limit to increase if the unit is renovated after it has been vacated? There is no limit. It goes to market rent also. What reasons will be acceptable for terminating a lease? Went through those. That's the failure to pay rent, material violation of the lease, unlawful purpose. Those hosts of those 9 or 10 reasons. And they say examples: wanting to renovate an apartment, illegal occupants, poor payment history, animal issues, housekeeping issues. Yes, as to all those. Wanting to renovate an apartment, you have to just make sure it qualifies for those reasons in terms of substantial renovation under the code. What notifications will be required? Will you be supplying forms? Are there penalties for not supplying these forms? What forms a delivery is acceptable? U.S. mail, email, hand delivery, etc. The form has been drafted, and the type of service, it's going to depend on the type of notice or the type what you want. But most of it is by U.S. mail and posting, or personal service, or substituted service. It's by giving someone a suitable age and discretion, or posting and also mailing. Email so far is not a valid service, unfortunately. Other questions. What are the rules regarding evicting tenants in order to put a property up for sale? There is no exception for this. So if the property was to be sold, the new owner takes subject to the lease of the existing tenant. In Santa Barbara, we have a local city rule that we must provide 3 months of current rent to a tenant that we're asking to move out in order to move a family member in. The state law requires that I provide 1 month of rent in the same situation. The local rules trump state rules. This pertains to a non-owner occupied duplex. So if your non-owner occupied duplex is covered by Santa Barbara city ordinance, then that's what is going to apply first. And then the AB 1482 is not applicable. Okay. We are receiving mixed information to use the current CPI, but then we are being told to use CPI from April to March of 2019 and have been able to confirm which is correct. Can you provide assistance with this number to use? Well, unfortunately, the legislature drafted the statute and they put April to April, but they were not aware that majority of the counties in California are not produced for April CPI. The only thing we can give is probably the more conservative is do the March to March and look at that, since there is no April CPI. Okay. We are waiting with bated breath, of course, for an official explanation from our San Francisco Rent Board. We asked whether a jurisdiction can pass a tighter rent control measure after 1482 becomes effective. Yes, they can. However, there are some provisions of Costa-Hawkins still survive. So, of this. And then the second part of the question, some buildings built after 1975, the date after which buildings have been exempt from local rent controls will be affected by 1842, possibly. After the San Francisco buildings become 15 years old, will they become subject to AB 1482, or are they subjected to a much stricter San Francisco laws? What will happen is, if they are not currently controlled by the City of San Francisco rent control ordinance, and they will be applied, if they then follow into this AB 1482, they will do so. As time rolls on, if they're newer than 15 years, they'll fall into this AB 1482 unless the City of San Francisco modifies their rent control jurisdiction ordinance. The question is whether jurisdictions can pass new local laws which are stricter after AB 1482 comes into effect. At this point, it seems yes, that they can. Can owner occupy one of 3 attached units in the building and rent out the other 2 and be exempt under AB 1482? No. And then what about triplexes? Triplexes are all included in the AB 1482. Okay. And then tenant is Section 8. Do the same laws apply as tenant in regard to rent increase and protocol to remove the tenant? No. Section 8 has their own set of rules as to how much you can increase the rent. You have to get permission from the housing authority to do so prior any rent increase. Okay. So this would not apply. Tenant is currently on a rental agreement. Can I give a 60-day notice? The only way you can give a 60-day notice is whether or not if you fall into with AB 1482. If you don't, you can then turn around and give a 60-day notice. However, if 1482 applies to your property, you won't be able to terminate because you have to either do the no fault or the fault under this AB 1482. Okay. Will late payment of rent be a just cause for termination of a tenancy? Late payment. The failure to pay rent certainly will be. Question is, late payment of rent be a just cause? We still argue or advocate that the late payment is still a material term of the lease, so we'll keep with that. How does month-to-month rate fall into this regulation? It includes any month-to-month rate, so it has to be within a 5% plus CPI increase. I understand that the rent control law does not apply to single-family owned by individuals. How would anyone determine if a single-family residence was owned by a corporation business and thus subject to the rent control law? And it's simply the title. How's title taken to the property? Okay. How does the law affect low-income individuals when it comes to applying for affordable dwelling units, and will allow those vouchers to have an option for choosing where they want to live? If you have a regulatory agreement, that will exempt you from this provision, AB 1482, and that's what I would look towards. And are new construction units subject to the Tenant Protection Act? No. Remember, we have a rolling 15 years. Okay. Is there a required format or time frame for notifying residents who may be subject to a rental rate decrease on January 1st, 2020? No, there is not any formal. Does the definition of rent under the statute include charges for utilities? There is no definition of rent in the statute, unfortunately, and I think that's where we're going. Is that the rent is going? Then the courts will look to what's rents defining your lease agreement. Does the statute allow for fluctuating of utility charges or even the increases to utility rates separately from the allowed 5% increase? Or will any increase to utility charges eat up the allowable rent increase? They certainly could. If you don't have the RUBS system in place, then I think then the owner then is being charged and having to pay those. Certainly, those are going to eat up into your rents. And that's why I think it's important to have a RUBS program in place at this point in time. Does the 15-year-old exclusion mean that buildings built in 2004 are exempt forever, or are they under rent control the next year as they become 16 years old? I'm taking a highly conservative approach. I think it's day-to-day as to when your certificate of occupancy was issued, and in fact, all 2004 properties are part of the AB 1482. It's 2005 and newer dates. Can you address the effect on properties that are currently rent controlled? Keep operating as you are now. There's no difference. If someone is currently on a month-to-month and they convert to a lease, and in January we do a 7% increase, would the month-to-month fee be included in that increase if they choose to go month-to-month? Yeah, that's going to be the problem with the month-to-month increases, that they have to fall into place with that 5% plus CPI. So if you charge the rent plus a month-to-month fee and it goes over that amount, then it's an invalid rent increase. So that's going to change the way parties have been doing business in California. Here's an example. I raised my rents by 9.9% on October 1st, 2019. What do I have to do to reduce to starting January 1st, 2020? I read it 7.9%. Properties are not under rent control and not under the City of LA, but they are in LA County. If you're also not affected by the LA County rent control ordinance or the City of LA, an example is you increased it 9.9%, you're allowed 8.3%, so you'll have to reduce it to 1.6%. Okay? So you'll have to reduce the 1.6%. And remember, the tenant does not get a refund. That was specifically added into the bill, into the law. If when we renew leases, the residents that do not respond, they get a month-to-month fee of $100, is that considered a rent increase? Yes, that will be considered a rent increase. And then someone has specific questions regarding accessory dwelling units and whether or not they are exempt. In cases, yes, they are exempt. Will an owner of a single-family home be allowed to terminate tenancy with proper notice in order to sell the property? If you do not have AB 1482 apply, if you owned it as an individual, then you can certainly terminate without any problems, as long as they're in a month-to-month or a conclusion of a lease term. If 1482 does apply, you hold the property in, our REIT, our corporation, or our LLC owned by a corporation, then you cannot terminate the tenancy unless you have one of the four reasons to do so. Okay, for no cause, and selling a property is not one of them. Okay, and San Francisco, as you know, has a 6.11 section to its rent ordinance that permits adjustments for such favored rental arrangements through petition and hearing process. Does the state law? No, it does not have any. It has no argument for capital improvements or anything to increase the rent. It has nothing.
We'd like to thank Todd Briscoe for his time today. If you have any questions regarding the material you learned in today's webinar, please feel free to reach out to Mr. Briscoe. Thank you.